What happens when a company goes into receivership? When the company goes into receivership, senior management and the directors lose most of their authority for decision-making. The director's general corporate duty of maintaining corporate records continues, but any decision-making about the running of the business or its assets will not be effective. This is especially true in a court-appointed receivership. The subject of director liability is too broad to start mentioning in this Brandon's blog. I am planning to soon write a blog on that topic. Management's and employees' responsibilities concerning the business in a practical sense will cease upon the appointment of the receiver. Their input and assistance is only required if requested by the receiver. They certainly will not be paid for any efforts unless the receiver agrees in writing to make money available for their pay. Ontario Court of Appeal says you better move fast. Why the confusion? Isn't the process for an appeal of a court order straightforward? The confusion comes about because, in the Standard Model Receivership Order of the Commercial List of the Ontario Superior Court of Justice, the court appointed a receiver is appointed under two statutes. Section 101 of the Provincial Ontario Courts of Justice Act, RSO 1990, CC.43, CJA. The Federal BIA, Section 243(1). The applicant, in this case, was the purchaser of assets from a court-appointed receiver of a company. One of the standard provisions in a receivership appointment order, is that anyone wishing to take legal action against the receiver must first get the approval of the court to do so. They brought an application for authorization to sue the receiver over a disagreement arising from the purchase of the assets from the receiver under the Asset Purchase Agreement. On May 17, 2018, the lower court judge dismissed the application, finding that their allegations were not supported by the evidence. On November 8, 2018, the same judge refused their demand to resume the application based on new evidence. The applicant filed appeals from both decisions. Its notices of appeal were on time under the provincial CJA, under which there is a 30-day time limit for commencing an appeal. They were late under the federal BIA, which imposes a 10-day time limit. The lower court judge dismissed the appeals. He held that the BIA was the governing authority for the appeal, not the CJA. He stated that the origin of authority under which the receiver was appointed was Section 243(1) of the BIA and therefore appeals are governed by the BIA, not the CJA. He further went on to say that the appointment also under the CJA did not have the result of ousting the BIA as the source of the appellate authority. He further held that it also cannot supersede the fact that the federal BIA holds paramountcy over the provincial CJA.